Thank you all for being here today. I'm Nancy Hoffman-Vaniuk, CEO of the Greater San Fernando Valley Chamber of Commerce, and this is our annual labor law update. Of course, this is for 2022. And I want to welcome our presenter, Kristina Kourasis of Landegger, Verano, and Davis in Encino. Kristina is a top-rated employment lawyer in the San Fernando Valley and was appointed to the Chamber's Board of Directors in 2019. Before joining the firm, Kristina ran a solo practice devoted to advising employers in employment law matters and representing employees in a wide variety of employment disputes. Upon joining Landegger, Verano, and Davis, Kristina discovered her passion for educating, training, advising, and defending employers in all areas of labor and employment law. She is a regular presenter before many HR and business organizations. I don't know why that's having feedback, throughout Southern California. She is a strong believer in ongoing education and training, and she publishes many blog articles to keep clients informed. Kristina is a member of the Labor and Employment section of the State Bar of California, the San Fernando Valley Bar Association, and the Eastern European Bar Association. So before we get started, I just want to ask everyone to put yourselves on mute, so that way you can hear the presentation, except for Kristina. And I'm going to turn it over to her so that way we can maximize our time today and you can learn all about the new employment laws that are taking effect in 2022. Welcome, Kristina.
Thank you for the introduction, Nancy. And I'm going to share my screen right now. Here we go. Can everybody see that?
Yep.
Okay, perfect. So let's just jump right into it. Thank you for joining us this morning. I'm going to jump right to the most fundamental update, which is the minimum wage increase. And effective January 1st, 2022, California updated the state minimum wage, and the increases are listed here. As to the hourly minimums, they're going to be increased to $15 per hour for employers with 26 or more employees, and to $14 per hour for employers with 25 or fewer employees. There are some local variances that are going to apply to the city of LA and the unincorporated areas of the LA County, which I'll go over in just a second. I have here a moving piece that shows you what the salary component is going to be. And this is the California salary minimums, and they are applicable to the city and the county of LA because the labor code section pertaining to the California state is applicable locally. So these are the numbers that you're looking at, whether you have employees that are 1 to 25 employees or 26 plus employees. This is what you have to pay them in 2022 if they are exempt. Let's move on. I also created a slide here that covers the minimum wage for the city and the county, in case that's where you perform business. And this goes into effect in July. I just wanted you to have a heads up. As of July 1st, as of July 1st, the minimum wage for the city of LA will increase to $15 per hour for companies with 25 or fewer employees. It's going to stay at 15 for companies with 25 or more employees. Also, for anyone who performs business in the county of LA and unincorporated areas, the minimum wage will stay at $15 for companies with 26 or more employees, and it will increase to $15 per hour for companies with 25 or fewer employees. There are also specific industries, specific sectors that you want to be familiar. If you're in the computer industry, the special minimum wage for the salaried exempt status for computer professionals will go up significantly. You want to do the analysis to make sure that this individual is in fact a computer professional, which is a pretty technical analysis if you look at the labor code section. And it's going to describe very specifically the types of duties that the employee performs. So you want to do the analysis to make sure that you are not underpaying an employee who falls within this category. I want you to be aware that in February, the California Supreme Court issued a very significant decision that's affecting most of our clients, and it pertains to the way that you record meal periods, okay? So previously, our clients and everybody in the state of California used a rounding technique that, you know, made sense to most people. And you want to be aware that as of this Donohue decision, that is no longer allowed when it comes to recording meal periods. So California Supreme Court held that rounding when it comes to meal periods is simply not allowed. Okay, and we can address this further during Q&A. Just real quickly, if it applies to you, SB 62 is now in effect, and beginning January 1st, it expanded the definition of the garment manufacturing industry for purposes of wage claim enforcement, and it includes brand guarantors. You want to be aware, if you're in the industry, that employees in this industry may not be paid by the piece rate or unit, but they must be paid at an hourly rate unless you have a collective bargaining agreement in place, which has very specific requirements as well. So you just want to be aware. Moving on to SB 657, which is now in effect beginning January 1st. It allows, I think this is very convenient for you. It allows you to distribute California required posters to those employees who are working remotely via email. However, you must know that you're still required to physically post any required postings. So this just, I think, is a good CYA to say, I did send this email. These are the people I sent it to. They received the notice. So I think it's an added benefit for you. Moving on to SB 807, it's the employer record retention, and effective January 1st, 2022, employers are now required to keep records for 4 years. And I recommend that you preserve personnel records for any employment applicants and employees for 4 years from the date that the records were created. After an employee is terminated, you want to make sure that you retain their personnel file as well as their payroll and time records for 4 years. Or when an applicant is not hired by you, you want to make sure to maintain their record of the application and the denial and anything else you might have on file for them. Moving on to AB 701, this pertains to warehouse distribution centers, and effective January 31st, 2022, anybody in this category, they're prohibited from any quota that prevents an employee from meal or rest break compliance, use of bathroom facilities, or travel to and from the bathroom. And it also specifies compliance with California occupational health and safety laws. So you want to make sure to look at this and let me know if you have any questions during the Q&A. I want to zip through to AB 286 pertaining to food delivery prices and tips. If you're in this sector, this new act makes it illegal for food delivery platform to charge a customer any price that is higher than the price that was posted on the platform's website, depending on what website you're using. It prohibits the food delivery platform from retaining any portion of amounts designated as a tip or gratuity. I know this makes my Grubhub delivery driver happier. And it requires a food delivery platform to pay any tip or gratuity for delivery in its entirety to the delivery person. And it also requires a food delivery platform to disclose to the customer and the food facility a cost breakdown of each transaction. And by the way, this applies to a single warehouse with 100 plus employees or 1,000 plus employees across the state in California. AB 1003, you really want to be aware of this. California has really ramped up punishment for unpaid wages. I think they really took it to the next level. Based on AB 1003, it can be considered and punishable as grand theft. If an employer intentionally fails to pay wages, and this is the breakdown over here that you want to be aware of. Now, the key here is intentional, right? Which is going to be reviewed at very carefully. So if it's an oversight, an error, you're going to be fine as long as you have the documents to show for it. But if it's intentional, if you've got a pattern going on and it is in the amount greater than 950 as to one employee or 2,350 combined to two or more employees within a 12-month period, you may be looking at very serious repercussions. So you definitely want to be aware. This next one, SB 631, pertains to persons with disabilities. And I know that a lot of my clients and a lot of the people on this call may be in the sector. So previously, employers were able to have exemptions and apply for permits to be able to pay a reduced wage to individuals with disabilities, mental or physical disabilities, when they're in certain contracts performing certain tasks. You want to be aware that no new permits can be issued after the beginning of this year. And I know that certain permits that are already in place will be phased out, but slowly by January 1st, 2025. So you definitely want to re-examine if it does apply to you, whatever you have in place, make sure that you're compliant. This is an added update to CFRA. It adds, effective January 1st, 2022, it adds a parent-in-law to the list of family members for whom an employee can take leave. I also like this second part of it here. 1033 mandates that the DFEH notify an employee in writing of the requirement for mediation for DFEH's small employer mediation program. This applies to employers with between 5 and 19 employees. So I think it's a good safety if you end up in litigation that the employer can undergo the DFEH mediation program before the case ramps up to be in civil court. So I think it is a good option. AB 1506 is expanded and revises independent contractor exemptions. And this extends for 3 more years to December 31st, 2024. The temporary exemption for newspaper publishers. If you're in that industry, we'll talk about it in greater detail. You want to be aware of SB 331, Silence No More, which limits the non-disclosure agreements and settlement agreements to make sure that you have a specific provision in these agreements. If you're going to have an NDA or a settlement agreement, that you want to be aware that the law prohibits that you prevent the disclosing the factual info pertaining to a sexual assault, sexual harassment, discrimination, and other acts based on sex. This would be a situation involving either an alleged sexual harassment case or an actual sexual harassment case that was filed, in court. If it is settled, you want to make sure that you have the proper carve out in the agreement that carves out anything that pertains to these types of allegations. Otherwise, it will not hold up in court. SB 762 pertains to the timing of fees and costs due in arbitration. And this is also effective January 1st, 2022. It addresses situations where a company does not promptly pay the arbitration fees. as an employer in California, if you do have an arbitration agreement, I think there are a lot of benefits to having that type of agreement, especially if you have a class action waiver in it that waives employees' representative class action claims. I think you want to be sure to be updated on this, and feel free to ask more questions. I didn't think that this update would be sufficient at all if I didn't address COVID stuff, which has been a very big topic of discussion this whole year. Well, I should say the entire year of 2021. So I wanted to just quickly go over kind of like highlights of COVID. One of the most common things that I get asked about is COVID paid sick benefits. And I want to just address that on the state and the federal level, those benefits are gone, right? So the FFCRA is gone. And you want to be aware if you are either in the city of LA and you have 500 or more employees, or if you're in the LA County and you do business in the unincorporated areas of LA County, you want to make sure that you know that there are local ordinances that are in place that you are likely subject to, which require you to provide supplemental paid sick leave to employees. And I can address this in the Q&A to help you determine if you are subject to those ordinances, and if so, what you should be providing to employees who are out with COVID sick. The other thing you want to be aware of is effective January 14, there is a new version of California OSHA's Emergency and Temporary Standards, the ETS, that's in place. And again, in terms of COVID benefits, I get this question all the time. Exclusion pay is still in effect. And exclusion pay is essentially replacement wages for employees who are being excluded from work due to COVID exposure or due to being COVID positive. As long as you do your investigation and you have your paper trail that shows that the employee either didn't get it at work or did get it at work, or it's more likely than not that they got it at work, you want to make sure to do the investigation, because if it was a work-related exposure, you are on the hook regardless of how many employees you have as a California employer for paying exclusion pay. And essentially, you have to continue to pay the employees their earnings, maintain their seniority and any other benefits. And you want to be aware that there are exclusions from this. If the employee, for example, ends up working remotely, then you don't have to pay them exclusion pay, you just maintain their regular wages. And if you do the investigation and you determine that this exposure was not work-related, if they got it somewhere outside of work, then they don't qualify for exclusion pay. Another question that I think is very key, very important for you to be aware of the answer to, is that you cannot require your employees to use their standard paid sick leave under Labor Code 246 that California mandated. If you're in California, you're mandated to provide 24 hours. If you're in the city of LA, you're mandated to provide 48 hours. The point of this slide is that you cannot require those employees who qualify for exclusion pay to first use their mandated paid sick leave. What you have to do is you have to pay them the exclusion pay, their replacement wages, if the exposure is work-related. However, some of my clients have a more generous paid sick leave policy or a PTO policy that doesn't designate number of hours towards vacation or paid sick leave. So employers that do have a more generous policy than what is required under the law, if they're in California, they're required to have 24 hours of paid sick leave. If they're in the city of LA, they're required to provide 6 days or 48 hours. So if you provide a more generous policy, then you may require your employees to use that separate portion of that paid sick leave first before paying out their exclusion pay. And as to the remainder, though, you cannot touch it unless they prefer to use that.
Kristina,
Yes.
before you go on, there's some questions that really go with these things you're asking.
Oh,
Can I just
perfect.
give them to you right now? I mean, there's a lot of questions, but
Yes.
so I want to do all the ones that kind of relate to COVID right now. So does the LA County leave have an employee size threshold?
LA County leave?
Yeah, you had on the
No, it does not. The only requirement is that you must be performing business in the unincorporated area of the county. And if you Google it, you can find a list of, if you don't know it offhand, a list of those areas in the county of LA that are considered to be unincorporated. If you're in one of those areas, then you are automatically required to, you are subject to that ordinance. You want to make sure and look at the ordinance because it does have offsets. So for example, it'll say something like if you've already paid these benefits under the FFCRA or under other supplemental paid sick leave on or before March of 2021, then your requirement to pay any additional hours is going to be offset. Okay, so it doesn't, you don't have to pay it twice. In other words, you just want to make sure to look at it and see if it still applies to you.
And then you have the one that had the city and the county, the different changes. Is the 500 plus count the total employees who work, live in California? That was under the city.
That's
or is the
city of LA.
total head count for the organization? So it's 500 total employees in the city of Los Angeles. Oh, in California.
In California.
But if your
Yes.
business is in the city of LA.
But if your business is in the city of LA.
Yeah,
Yes.
so if you're in a different city like Burbank, Glendale, Calabasas, or anywhere else, not within the city of LA, then that applies to you. I just want to clarify
Right.
that. And then can employees use their PTO or accruals for the exclusion pay? You just explained it, but you want to just elaborate a little more?
Yes, absolutely. So the answer is if your PTO contains more than, let's say you're in the city of LA, so you're required to provide 48 hours of paid sick leave. If your PTO, which translates into 6 days, if your PTO provides for 10 days, then you can use those 4 extra days towards exclusion pay. In other words, you can use those 4 days first. You can tell the employee, we're going to use the 4 days that you have available under your PTO before we kick in the exclusion pay, which really helps you because now based on the revised shorter quarantine and isolation days, if an employee tests negative on or after day 5, they can return. So if you have a generous PTO policy that has extra 4 days on top of the 48 hours, then really all you have to do is pay an extra one day of exclusion pay, and then they come back.
And then someone asked, they thought the ETS was stopped. Is exclusion pay still required?
It was actually revised, and a new version is now in effect that includes exclusion pay. So yes, the answer is it's still in effect.
And is that the OSHA or Cal OSHA?
Cal OSHA.
Okay.
Yeah, Cal OSHA just revised their ETS on January 14th.
Okay. And let me just see if there's anything else that's related to this. So the other questions have to do with things that aren't on these slides, so we could do those at the end because they're pretty easy.
Okay. Perfect. So I'd like to open it up to any further questions.
Oh, I have a few in the queue, so hold on then.
Okay.
So under SB 62, can you pay a wage plus piece rate?
So what SB 62 basically says is you may not pay by piece or unit or by piece rate. So the requirement is basically for you to pay at an hourly rate. So you cannot pay an hourly plus piece rate.
Okay.
Okay.
Then Regarding meal periods, is it enough to make the period available, or does the employer have to make sure that the employees take their full meal period?
I'm not sure entirely what the question is, but the answer, but this is what I'd like to say to that, is that you need to make sure that the employee is taking a full 30-minute, minimum 30-minute meal period. Because typically before this law went into effect in February of 2021, most of my clients, if not all of my clients, were rounding. And so when they were rounding, there is still an actual record of the time that the employee actually took their meal if they punched in and out. So if you were to look at their time record, and if based on the time record, the number of minutes that they took for their meal is less than 30 minutes, there is going to be a presumption of a meal break violation, which entitles that employee to a meal break premium. So if that's the case and you round it up and the payroll records are going to show the rounding, you will have wage and hour exposure for, you should have paid the meal break premium for every time you have that type of situation. I hope that answers the question.
So if someone, I'm offering my employee this meal period, and then they took 30 minutes, but they got an hour. Now they're working overtime. Now you have to pay them the overtime for those 30 minutes, correct?
Well, the
So
30-minute meal
I give them an hour, but they
Yeah.
only took 30 minutes because that's all they
Yeah.
need to do by law. But
Yeah.
now that put them over 8 hours, that means we have to pay the overtime, correct?
Yeah, if they chose to take a 30-minute meal, which is what the minimum required under California law, if they chose to work for during the other 30 minutes, then that is going to be considered as time work that will add to the number of hours that they work during the day. So if it pushes them into overtime, then yes, they are entitled to overtime.
Okay. And then with regards to keeping personnel EE files for 4 years after termination, can they be electronic?
Yes, they can be.
And that's all the questions in the queue. Are there other questions? If you want, you can either raise your hand or you can unmute yourself really quick. Or do you have more slides?
I don't have more slides. These are the key updates. And if anybody has questions about COVID sick or the shortened quarantine times, I'm happy to answer any of those questions.
Well, if there's no questions, I'm gonna stop your screen share.
Can I ask a question?
Sure.
Thank you so much. So we have a small shop with about 5 employees, and we've had a real problem with the meal break things where we have a gentleman who wants to clock out half an hour early, so works from 9 to 5 and wants to clock out 4:30 and said, well, I didn't eat because I fast. So he still by law has to take that 30-minute break, and that can be something we can at least write him up for refusing to take a break because he's refusing to sign out.
Yes, you can write him up. What I would do is I would make sure that every time an employee refuses to take a mandated meal period, that you do have it in writing. Okay. And make sure to either send an email or have him send an email, and and so that you can have it as a defense.
Got it.
And make sure that he is punching out properly to indicate that he only took a 30-minute meal break, so that you have an accurate record.
Okay, and then the other challenge we have a driver who does deliveries. And what he's been doing is he'll leave at 9 o'clock in the morning. He'll come back to the office at 4 o'clock in the afternoon, and at 4 o'clock punch out for his lunch, which when I'm reading up, he's supposed to take his lunch by 2 o'clock.
Yes.
Because he's on the
violation.
phone.
Yes, he is violating the meal break law, and if you don't have a written policy, you may be in trouble. You want to make sure to have a written policy that says that every employee, including the drivers, must take their meal break before the end of the 5th hour.
Mhm.
And if they're choosing not to, again, you want to have a good record of that in an email, in a letter, in a text message, so that it can act as a defense.
Okay.
But you want to make sure that they are, again, keeping track and that it's accurate on their timesheets. That's the only way that you can prevent that you can defend yourself in an action. And if you have a lot of employees, that can really turn into a class action. So you want to make sure to have a written policy, and you want to make sure to the extent possible, document every voluntary deviation from that policy as a defense.
Perfect, thanks. And if I can ask a question about COVID benefits. So it's my understanding that folks can no longer file for California state disability for COVID leave, correct?
I'm not aware of that.
Oh, I thought that's what she was saying, how that the federal and state will no longer provide.
No, what I was talking about was the, so back in 2021, 2020 and 2021, we had a federal act called FFCRA, Families First. And that expired, those benefits expired as of September of 2021. That's what I was referring to.
Okay, not California state disability, okay.
Correct. Employees can still file for state disabilities.
Okay, great. And then, but our employers are now mandated to provide COVID paid benefits if they believe the exposure was on the job?
Correct. Under the California OSHA emergency temporary standards, the ETS, you are required to pay their replacement wages, what's called exclusion pay, if you determine that the exposure was resulted from an on the job interaction.
Is exclusion same as their regular wages, or is it smaller, or is it?
It's the same as the regular wages that they would have, the number of hours they would have worked if they were not excluded.
How the devil do you determine whether
You do your best. I mean, the most conservative approach obviously is to pay.
a job or not?
Yeah, the most conservative approach is to do your investigation, and if you just cannot determine, but it looks like more likely than not that they got it on the job, then you do provide the exclusion pay. But it is going to be a business decision, and I'm not suggesting that you go out of business trying to pay exclusion pay. You do what you can. You make sure to do your investigation and to have a good paper trail that shows, they were out on vacation, they went to their grandma's, their grandma has COVID. So you want to you want to interview them and get all the facts. And then if it looks more likely than not that they got it at work, you have a decision to make whether you're going to take the risk or, or not.
Gotcha. Okay. This has been extremely informative. Thank you so much.
Oh, you're welcome.
Okay, Kristina, we got some more questions in the queue. Can you share the link on the exclusion pay? And you could give it to us later and we could send it out to everyone.
Sure. I'll share the link to
the website.
California ETS, that has the revision, and it has really good Q&A. So that's on the Department of Industrial Relations website. So I'll share that for sure. Or I can send it to you and then you can share.
Okay. You can actually, you could, but I'm just saying, people can Google Cal OSHA ETS and it will take you to the page with the FAQ, because I do it all the time.
Perfect.
And I also put it in the, it's also in the chat as well. We'll send it in
the chat.
addition. Yeah.
Okay. Perfect. And let's see, because we have a bunch of questions now. Regarding lunch breaks, can you force them to take lunch before the 5th hour mark, or just ensure that they are provided an opportunity to take a meal break before the 5th hour mark?
I would say that you definitely, at a minimum, are obligated to permit and authorize that meal break before the end of the 5th hour. That's based on the California decision, Brinker, and for years now, it's been your job as an employer to make sure that you permit and authorize. I think that more recent decisions have been more strict with respect to your obligation as an employer. So this is why I say, make sure to document any deviations from your actual written policy and or practice. And if an employee says, I just don't wanna, I'm fasting, I don't have time or whatever, make sure to send an email and say, this is to confirm, or have them email you that says, I just don't want to do it, so that you have the defense. Because on the face of the time records, if their timesheet shows that they took a late meal, an interrupted meal, or a short meal, you are on the hook as an employer under California law for paying that meal premium penalty. So unless you have a defense by way of, some writing, you're going to be on the hook. So you want to be diligent about recording any deviations.
And I'm just going to add this, that who cares if they're fasting? They still can take a break. They could go read a book. They could go make a phone call. They could take a nap in their car. I'm saying this because as the chamber, we host events with meals, and people tell us we're not going to eat. Well, we still have to pay for that event. So, food is the extra part of being there for that time period.
Especially the bacon.
Can you please review the new COVID protocols, including the shortened time frame?
Absolutely. So what you want to do is you can go on, I'll circulate a link that Nancy can share with everybody. But essentially, the shortened time period is now 5 days. So for all employees who test positive, if an employee tests positive, you have to exclude them, and for at least 5 days. However, they can, assuming their symptoms are subsiding or going away completely, as long as they test negative on the 5th day or later, they can come back with a negative test before the 10th day. If the employee is unable to test, they just self-isolate for 10 days, and they come back without a negative test, okay? So they can just come back to work after 10 days, assuming they don't have any symptoms or their symptoms improved. Okay, those employees who were exposed to a COVID positive, they basically have to be excluded for the same period of time for 5 days, and they can test 5 days or later. And this is 5 days after the close contact, and they can come back 5 days or later with a negative test. If they're unable to test, if there's a shortage of tests and they cannot get a test, or they don't want to take a test, then they just stay out, quarantine for 10 days, and then they can come back.
Right, and I think you answered this. For clarification, the meal break must start before the 5-hour mark, correct?
Correct.
Okay.
Yes, before the end of the 5-hour mark. Yes.
So it has to be 4 hours, 59 minutes.
Correct.
No later.
Yes.
Right.
I answer this question every year.
For Cal OSHA exclusion pay, must the employer have a certain number of EEs for this to apply?
No, applies to everybody.
Does exclusion pay get paid at the regular rate of pay or the base pay?
Yes, regular rate of pay, correct.
So
yeah, if you're paying out commissions, bonuses, any of that stuff, you must factor those into your regular rate of pay, including when calculating your overtime.
In order for associates to return to work after 5 days of testing positive, must they test negative first after the 5 days? If so,
Yes,
where is that written? What can I show my boss to prove that they need a negative test to return?
It's all over the web. We now luckily have that rule spelled out by every level, including the state, Cal OSHA, the CDC, as well as the California Department of Health. So if you Google I'd rather you Google the California Department of Health. I can also forward you a nice chart, or I can send it to Nancy and she can forward it to you.
Send us the chart, because we could probably put it in a newsletter too.
I'll email it, and then Nancy will share it with everybody.
For return to work, are we required to pay for the test if they tested positive outside of work?
The most conservative approach is to pay for it, because if you're mandating the test, then under California law, the labor code requires that you reimburse employees for any necessary business expense. And if you're mandating it, then it becomes a necessary business expense. So I do recommend that you pay for it.
Okay, and then Holly, you have your hand up. So you want to ask your question?
Hi, Holly.
Are you there? Holly? Okay, I'm going to go on then to the next person.
Okay.
If an employee clocks back in multiple times at the 28 or 29 minute mark, do we need to pay them a meal premium? Do we just need to let the employee know that they must take a minimum 30 minutes?
Okay. So if the employee is clocking in earlier because their job requires it, a client came in and they're like, oh shoot, I cannot complete my 30-minute meal break. Then yes, you owe them for the meal premium. You owe them the meal premium. If they are volunteering to clock in earlier, for any reason, for any personal reason, then I want you to make sure to take note of it and talk to them and let them know that that they are required to clock in 30 minutes after, that they get 30 minutes, and make sure if they want to keep doing it, that they do email you and you have something in writing that shows that they're volunteering to take a shorter meal break.
If an employee tests positive, does their negative test have to be on or after the 5th day, or can they get the results on the 5th day?
The test result has to come on or after the 5th day. So if they tested before the 5th day and it's negative, then that's not sufficient. It has, presumably they wouldn't have gotten it again, but technically we want a negative on or after the 5th day.
Okay, so let's say you got your test on the 4th day.
Yeah.
And then it's negative, but it doesn't come back till the next day. That's the 5th day.
I know, but look, I think it's fine. Okay.
I'm just putting it out there.
Right. No, it's a good point, because the thing is that the CDC and the California Department of Health, they are recommending that employees take an antigen rapid test, because if you take a PCR test, you're going to keep testing positive for up to 90 days, right? Because the virus is still going to be in your system. So, and antigen tests are known to be less reliable. So just to be safe, I would make clear to tell your employees to test on or after the 5th day, so that you're absolutely in the clear that it's negative. But I think if the employee doesn't have any symptoms and they tested negative on the 4th day, I suppose it's fine. I just want you to be aware that it's a slippery slope, that if you start, if you start letting employees test on different days that violate the mandate, then you might be in trouble. So just be careful.
Can you please provide clarification on using PTO as exclusion pay?
Yes. So basically under the ETS, under Cal OSHA's ETS, you're not allowed to require employees to use their California paid sick leave that they're entitled to under Labor Code Section 246. So what does that mean? If an employee has accrued paid sick leave in the amount of, let's say, 24 hours, right? Because that's what's mandated under California law. You're not allowed to take any of those 3 days. If you're in the city of LA, then you're required to provide at least 48 hours. That's 6 days. Again, if an employee is eligible for exclusion pay, you're not allowed to require an employee to use any of those 6 days for in lieu of exclusion pay. However, if you have a more generous policy, including a PTO that provides for more than 6 days, let's say if you're in the city of LA, let's say you have a PTO policy that provides for 10 days, of absences for personal time off, then you can mandate that the employee use those 4 days, because those are the 4 days on top of your 6-day requirement under Labor Code Section 246. And you can have the employee use those 4 days first before your obligation to pay exclusion pay kicks in.
Okay.
Does that make sense? Hopefully it does.
What is the look back period for the regular rate of pay for exclusion pay?
For exclusion pay, it would be if you're paying commissions and bonuses, it would be the work week. So you want to make sure that for each work week, I mean, I'm fine with you using a pay period if it's the same, but you want to just be able to factor in any bonuses and commissions that were earned during the work week in which they were earned, and make sure to factor those into the regular rate of pay. And I think it's also relevant when you look at any overtime pay for the work week. So you want to make sure to factor in anything that the employee received by way of bonuses and commissions during that work week to figure out the regular rate of pay for that, for overtime for that week.
I think you answered this, but I'm going to ask it again. Are we required to follow the mandate for the return to work criteria for those who were exposed regarding the 5-day rule? Can we ask for a negative test result instead?
Can you repeat that? I'm a little confused.
Are we required to follow the mandate for the return to work criteria for those who were exposed regarding the 5-day rule? Can we ask for a negative test result instead?
You are actually required to ask for a negative result for those who test positive and for those who are exposed, for both categories.
The negative test would be an antigen test. You said that, right?
Yeah,
Because once they test positive, the PCR remain. Okay.
Yeah.
You mentioned to have a paper trail for exposures or positive tests outside of work. What would be the best way to document this? Email to the employee or document the conversation?
I mean, either or both. I think you want to have a protocol where you sit down with the employee, or I'm sorry, you're on a phone call likely because they were exposed and you don't want them at your work site. So you have a phone call or an email, and make sure that you document either one, whether it's a phone call where the employee says, I traveled outside of this state, or I went to a party. Because the first question should be, where do you think you got it? And when do you think that happened? When was the last time you were at work? And when did you first start experiencing symptoms? Write all those things down. And some of my clients end up asking way more detailed questions. For example, in the healthcare sector, it may be a question like, there may not be anybody who tests positive in the workforce, but it may be a patient where an employee says, well, I had to take a patient to go get tested and they were positive, right? So you want to document who's the patient, how many patients did they see, who did they see that day? And that way, I think assuming you have the resources to do that level investigation, that would be the ideal in my mind, because that way you really have a clear record of how they got it. Also, make sure to submit every positive COVID employee to your workers' compensation carrier. And it's different than filing a claim. It's just submitting the information. That's a requirement. A lot of employers will also submit it as a claim, but typically you'll have to check in with the employee to make sure that they are willing to do it, because some employees just don't want to go through the process. But if you do go through the process of submitting every COVID claim, which may get very expensive, if you do that, it'll hike up your workers' comp rate. the workers' comp carrier will do their own investigation and return a finding of whether or not it was work related. So I guess there is some benefit to going that route.
Do self-administered at-home tests for COVID meet the requirements?
They do in most cases, but I think it's going to be a very industry specific inquiry, because some industries and also certain size employers may be subject to a heightened requirement that the tests cannot be self-administered.
Okay, for a close contact exposure to someone who was symptomatic and later tested positive for COVID, does the exposed person need to be excluded from work for the 5 days while waiting to test if they themselves are not symptomatic?
Yes.
Would this person qualify for exclusion pay?
So the answer is they may qualify for exclusion pay if they were exposed at work. So it doesn't matter if they're symptomatic or not. However, it would matter if they were able to work remotely, because if they're asymptomatic and they're able to work remotely, then they can continue to work from home and you don't have to pay them exclusion wages. You just pay them their regular wages. Okay.
Okay, hold on. I'm answering a question to someone. Hold on there. Okay, let's see. How many days are required to be paid under exclusion pay?
There's no cap. It's the number of days that the employee is being excluded.
So with the cap, so there is no cap.
There's no cap, no.
As long as they are symptom free for 24 hours without medication?
No, there is absolutely no cap for exclusion pay. However, now that we have shortened quarantine and isolation times, I suggest that you update your written policy, and also when you send out notices to employees, which are required under the ETS, you condition employees to come back 5 days with a negative test. So that way you tell them, you know, if you are COVID positive or if you're quarantining, you must quarantine / self-isolate, but can come back with a negative test on the 5th day or later. That way they know, okay, I'm going to come back 5 days later with a negative test. And at most 10 days if they don't test or if they continue to test positive. So that provides a guideline for how many days you're going to be paying them in exclusion pay. There are obviously going to be some deviations from the norm, some employees who end up being sick with COVID for 3 weeks, for a month, right? In that situation, I do strongly recommend that you file a workers' comp claim. Again, it's a cost benefits analysis and you have to determine whether it's worth it for you to do it, because it does hike up your rate for a while, for a long time. But at the same time, assuming that the employee is eligible for benefits, for workers' comp benefits, they're going to get their benefits. I think it's like it covers up to 75% of their lost wages and medical expenses. So it's something to think about for those long-term absences.
Under the new Cal OSHA ETS, I know you said it, what is the exclusion period? 10 days? There is no exclusion period. I mean, there is no max, right?
I'm sorry, under the what for exclusion?
The Cal OSHA ETS, what is the exclusion period? Is it 10 days?
No, so I want to just clarify that because the question is very vague. Cal OSHA ETS is California OSHA Emergency Temporary Standards. If you're asking what the exclusion is for exclusion pay, there is no cap on exclusion pay. But under the ETS, the quarantine and isolation period is now 5 days. If they can test negative on or after the 5th day, they can come back with a negative test.
To clarify, for submission of information to workers' comp, we submit every employee who tests positive, whether or not the exposure was at work?
Correct.
Okay. if you submit cover claim to workers' comp and workers' comp investigated and found out it's not a claim, will it shoot up your workers' comp regardless if the claim is denied?
No, no, it won't.
So that ends our questions, which brings us to the end of our webinar. Just to clarify, this is being recorded. We have to edit this recording because we're on earlier testing everything out. It will be on our YouTube channel probably by Tuesday. You will get an email letting you know. Now, with that said, if you did not personally register and someone registered for you and gave you the link, you are not going to get that email because we are only sending it to the people who registered through our website. And so make sure you reach out to us then so you can get the link. Kristina is going to provide us that chart. We will also include that in the email to all of you. Kristina, are you going to make the slides available as well?
Absolutely.
Okay, so we'll also send you the slides. And I do want to point out that there are a lot of new changes to our labor laws, and there are new posting requirements, employer posters. And thanks to Russell Lookadoo, the HR guy, he's on here today, he sponsored our poster. So if you are a chamber member, you will be receiving a free employer poster. Here, I'm going to highlight, or I'm going to spotlight him really quick. Here's Russell. So thanks to Russell, he sponsored the posters. If you're a chamber member, you will get one free. If you're not a chamber member, you can purchase them on our website. If you need additional ones for other locations, you could also, and you're a member, you can purchase those on our website, but they're available for non-members as well. And thanks to Russell, we were able to keep these at a much lower cost than we have in the past. So thank you, Russell, for doing that for us. Again, you do need new posters for 2022. We have them available in English and Spanish. So let us know about that. Fumi just put the link in the chat for those. If you don't know how to save the chat, which it won't make the link active, but go into the chat, and on the 3 dots where it says more, click Save Chat, and it'll save it to your computer. And with that, I want to thank Kristina for kicking off our Business in Focus webinar series with a really informative labor law update. Round of applause.
It's my pleasure, guys. You're welcome.
I'm going to end the recording and